Hey kids. I know this is late notice, but our I popped up on my stream that Adam Montgomery has a hearing today saying that his civil rights were violated. And so we are going to cover this because Adam Montgomery is the biggest POS uh this side of the Tobin Bridge or the other side of the Tobin Bridge. So I hope everyone will come and join me. If there's anybody out there, come say hello. I know this is really last minute, but I just found out about it and I really have things to say. Much like all of my viewers. If you are here, come say hello. Rozzy in the house. It's a pop-up podcast. Our felon Adam Montgomery, who is charged with the unaliving of his young daughter, who deserves to be under the prison, is going to the New Hampshire Supreme Court to appeal an oral arguments that his civil rights were violated. I have so many questions, Rozzy. I have so many questions. I don't know. I'm trying to get my Duquois all set up for everybody. Um, my 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 Nothing is put together yet. All right. Hold on, kids. Hold on. I'm almost ready. Oh, God. What is happening? What is happening? Rosie, help me. All right. I look like crap today. So I'm even going to go, woohoo! Heather's in the house. Hey, girlfriend. So I look like a mess because um I wasn't ready for this. I was clearly not ready for this. I just woken up out of bed. I'm working. Hey, Tracy V. Hello, lady. It's good to see you here. So, this case is going to be about, look at me, fresh faced. Um, yeah, what's going on a weekday? Yeah. Apparently Adam, our degenerate from Lynn, Massachusetts, who killed Harmony Montgomery and is in prison right now, is saying that his civil violations is he deserves to be out of jail because his civil rights were violated. I have so many questions. Does anyone else have so many questions about this? Because the man is a tyrant. I know. How are we doing on a weekday? I know. Well, I'm working, but then I saw this pop up. And Rosie, I put your sign, your picture that you made me right next to the other one. I'm very proud of it. Fuck that dude. He's right. Put him under the prison. He does not deserve Tracy V. Exactly. He is a scumbag. He is the ultimate scumbag for so many reasons. So, though I am working today, I might not be able to be on camera a lot, but I thought this was like we followed this case, most of us, right? We all followed this case, and I feel some type of way about him trying to weasel his way out of prison when he murdered his daughter in a vicious, vile, heinous way. Oh, hey, baby. He's the quintessential scumbag. It like doesn't get more scummy than Adam. So we're gonna watch this. Oh, hi, Sandy B. Thanks for joining us. And Mark. And Heather's here. I mean, is it a party unless Tracy V and Heather's here? These are like all my faves. I mean, I don't care if I have 100 people in chat. I don't care if I have 6 people in chat. The people who want to be here and hang out with us and talk shit about all these criminals, I'm about it, people. And you are always welcome here. Everybody is welcome here. And welcome to go wherever they want. Right? But you guys are choosing to be here with me to talk about, yeah. Girl, did you see that she's going after more money? Going after more money when she was the first person that failed her. Listen, as a mother, I'm not a perfect mother. Okay. I'm not a perfect mother. Is anybody a perfect mother? Is anybody a perfect father? But I do know that my son is well taken care of. He goes to doctor's visits. He doesn't get harmed. He is in extracurricular activities. And I choose to be a mother and put myself second to my child. And to me, that's a good mother. That is most of us mothers in the chat. That is most of our fathers in the chat. Everybody needs a little alone time into themselves sometimes. But the majority of my life is making sure that my son is okay. that my son is put first. It's the stuff that keeps you up at night. What is, dude? My brother's name is Adam, and I popped up and I saw it live, and I heard say Adam, that degenerate, blah blah blah. Sorry, Adam Adam's brother. That is too funny. Yeah, like normal parents, like when you become a parent, listen, there are a lot of people that are incapable of taking care of children and they do the right thing and they gave them to safe havens and up for adoption for parents who can love them the way that they cannot. And I commend those people. But when you are someone like Kayla, his baby mama or stepmother of Harmony, they're a paycheck, they're an EBT, they're a lawsuit. Where was Crystal for those 2 years that that baby was gone? I have so many questions, and if they even entertain this as his civil right, his civil rights, what about Harmony's civil rights? Because that girl deserved so much better. That cute little girl. Let's see if I can get a picture of Harmony and see how freaking cute she was. Let's see. Look at a picture. Harmony Montgomery. Images. Look at these scumbags. Look at them. Just look at them. Here. We're going to share screen. Share screen. Stop screen. And we're going to share this one because this is who hurt this. This is Harmony. God, why can I? There we go. See it? Why is my... Come on, man. Add me. And let's see if I can get Harmony up here. Yeah. Yeah. There's that little girl. That's Harmony Montgomery. Hi, Nat. Yes. Yes, girl. Yeah. Hey, Melanie. It's good to see everyone. It's good to see you guys. Oh my goodness. All my OGs. I will give it to you. I will give it to you. Yeah, this is her. Let's see if I can kind of pull it in a little bit. Um, let's see if I can pull this in. I mean, can she be more perfect? Hi, Stacy. I'm happy you guys are all here. We are going to go over poor Harmony. I mean, poor Adam Montgomery is pissed off that his civil rights were violated. But what about the violation you did to Harmony? That she has not been found, sir. I have questions about that. I have questions about you as a human being. You are not a good person, and you are exactly where you're supposed to be. As far as I know, from what I hear on the streets, as far as I know, he had to be moved to Virginia because he was... Oh, hi, three clerks. Good to see you, baby. Um, Harry Montgomery is a piece of shit. He's violated his daughter and he was supposed to protect. Yes. Amen. And if you know you're not a good parent, like there are so many people to take care of your children. The couple who adopted her brother Jameson wanted to take her, but Adam saw a paycheck. In my opinion, allegedly, all my opinions, I can say all the opinions because this is my channel. And if you don't like it, fuck out of here. That's how I feel about that. This is my opinion, commentary, reactionary channel. And if you have beef with it, find somebody else because I've had enough of people's fucking shenanigans. Mm, right. Right. That little girl was cute as hell. How could you ever hurt her? How could you ever hurt her? That poor little girl. And she had siblings. She had siblings that were not either touched or hurt. So she was, my beautiful Clarissa friend. Hi, mama girl. Thanks for being here. Um, The family who adopted the brothers are great. Yes, they wanted her. They wanted and this kid Adam ex-nayed that. It was like, no, she's a paycheck. She's a paycheck and someone to on because I'm a horrible human being. Did you see the mother lost her civil case too? Oh, good. Good. Good she lost it. Yeah. No, they haven't even found her. The mother, Sorry, Crystal Sorry, she said that she was raising money to do a search of the marshes in the Lynn Revere area. If you guys aren't from here, Lynn and Revere or Tobin Bridge, and it's likely where he dumped her many years ago, and she has never been found. And Crystal Story, her mother, who was the first person to fail her, said that she was going to raise all this money in order to go and locate her daughter's remains. And that has yet to be done. And also, she got a shit ton of money from the state of New Hampshire for neglect. Who really neglected Harmony? Crystal Story. And you have more kids. You have more kids. You have more kids. I can't. I cannot. Mm-hmm. Sorry, sack of shit. Oh, Chasey V, you already know that shit is gone. When Turtle Boy showed up at her door about the case, he could smell marijuana and drugs coming from her apartment that she had more kids in. People like her should be cut. Cut. No more kids. Hysterectomy. My opinion. I'm allowed to my opinion. That does not mean defamation. It does not mean anything. I'm not accusing anybody of anything, but I think in my opinion, bitches like her should get castrated. However a woman gets castrated, do that. She didn't even care about Tracy coming in with all the facts. Tracy, she didn't give a where her daughter was for 2 years. 2 years. If Caden is out of my sight for more than 5 minutes and it is too quiet, you know my ass is looking. One time he got out of my front door. Tell me why I didn't call the police. I didn't call everybody. I called everybody. And he was like around the corner. 2 years? Right. Let's see if it's on yet. It's not on yet. We're still waiting, kids. We're still waiting. I be right back. Sorry, guys. I'm having like a nasally, not feeling good today situation, and this is why I'm fresh faced and right out of bed because this just needed it. It needed it. It needed all all of the all of it. It needed all of it. Hold on here. All right. So I gifted to our Annie Lou. Yes, there's my painting. Your painting made the wall, Rosie. It's absolutely beautiful. And Cadence is actually hanging up in his room, and he absolutely loves it. We have a little light behind it, and so it looks kind of like it's really cool. I'll have to see a picture to show you. Um, hold on. Didn't this lunatic bring her bag to work? Something pizza plate. Yeah, she stuffed. Yes, Adam at the time worked as a pizza place in wherever they're from, Fall River. I don't know. Fall River just seems like the word to say. Brockton. I don't know. New Hampshire. They carried her dead body around in a bag, like a satchel, like a woman's purse, and put her in the freezer of the restaurant. Kids, where are we eating that this is happening? Yeah. Yes. I totally agree. I totally agree. She needs to be laid to rest, that poor baby. I've always thought that she went into the ocean because if you guys know the Tobin Bridge, at different times there are chances of throwing small bags over that over that, and that makes me just really sad for Harmony. Do I think that she'll be found? I don't know, but do I think that there should be efforts to try to fucking find her? Yeah, I do. Yeah, as a mother, you are a mother. When I became a mother, the first minute I found out that I was pregnant, I had a baby. I was a mother at that point, and all those instincts kicked in. Okay, it's either me and my kid, and none of these people were born with that, and I call that psychopathy. But who am I? Hi, Colleen. It's good to see you this morning. Yeah, they hid the girl in the ceiling of a shelter while they made another baby underneath it. They made another baby the natural way underneath a decomposing daughter in the ceiling. Who does that? Who raised these people? It's scary. The people who raise these people are raising the kids. Kayla's mother. Kayla's mother is raising these children. Yeah, right? Girl, we're using that egg donor. We're gonna start calling Crystal the egg donor because she wasn't no mother to none of her kids. Mhm. Amen. Yeah, it's very disgusting shitbag. I mean, like just being, I know that a lot of us are parents or we're grandparents where like all of these things, like to think of our children having to go such torment and torture, and this mofo is concerned about his civil rights. If New Hampshire still had the chair, he should have gotten it, in my opinion. Oh yeah, girl, honey, I live 25 minutes away. Give me the girls. I would have loved her and cared for her and taken care of her the best of my ability, and she would have been my own for free. I would have taken her for free. I wouldn't even want state aid to take care of her. What? Yeah. Well, Rossi, you're a father and a grandfather, right? So it's like you have double whammy. Let's see if this has started yet. It has not started yet. We're still, I don't know what time it starts, but I thought I would amazing grandfather. I always hear her talk. Right. Yeah. And too, you can tell a lot about a person about the way they speak about their children and their grandchildren. A lot of people who talk about their kids like they're a detriment and then like they're oh so much. They're oh so listen, Kung Fu Panda knows how to get under every nerve. Okay. Every nerve. But I will always look at him with stars in my eyes. And he makes me proud every single day. And I love his tenacity and I love his personality. And even the kinds that get underneath my skin because he's just like me. Like that boy just gives stars in my eyes. These people do not. They are a paycheck. And CPS not following through. Right. Heather, absolutely. Growing up wrong. Yeah. 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 These people didn't deserve to be parents. Like I think that they're like we have like a driving test when we're 16, like are you capable of driving a vehicle and not killing yourself or anybody else? I believe that there should be a certain type of test for parents. Because times in true crime are there so many parents that should never have been giving a uterus or a ball sack. I'm just going to say it. Panda is awesome. Thank you. Exactly. Yeah. All parents should have a deep love for their children. It's not about money. We don't have kids for money because shit, we don't get money. Right. Like I work a career and I do YouTube for free. And it's like my thing. It's like my outlet, right? Because I am such a parent that I do everything for my child, like extracurricular activities. I make sure that he's healthy and I ask if he's healthy and if he's happy or how his day went or how's school, how can I help you? Like I spend my life being a mother and I'm owned by my regular job. I do this for free. I don't want money off of people's misery, right? I just don't. Never have. What does it say? Ball sack center. Yeah, that was typical. You guys are too funny. I really hope this starts soon. Because I have a lot of shit to talk. I'm just saying. Oh man. I don't know when this is supposed to start. Does anyone else? You entered like 24 minutes ago. The mother would always say, count your blessings. Yes. Yes. Like, not for nothing. Like, hold on. Hold on 1 second. I have to go off screen for work really quick. Okay, guys. So I gotta go work for a little while. But I'm gonna leave the ad frame up on the screen and I will hear it and I will come back and we will discuss the atrociousness that will be Adam Montgomery. I hope he shows his face because he was a coward during the trial and couldn't even show up. Like, if you didn't show up to your daughter's murder trial when you say you didn't do it, working is overrated, Melanie. But they're calling me. I'll be back to a meeting. Okay, cool. So I'm gonna put this up on the screen for everybody, and I will be back as soon as it starts. Peace.
Marconi is disqualified in this case. And Attorney Flynn, I understand you reserved 2 minutes for rebuttal.
Yes, I have.
Please proceed.
Good morning. May it please they were not logically and factually connected in a manner that does not solely rely used has a propensity to engage in criminal conduct.
What
Make a
bearing-
difference. Does it make a difference that a different hedge is in first instance?
My recollection is that the parties agreed to joinder early on in the pendency of the cases. As they neared trial, the defense moved to sever them for trial. The state did not contest that the defendant had a right to do that and to have the
In the case, is what changed?
What changed is preparation for trial and additional information that was coming out about how the state was intending to present its case. And the defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are the Zwicker letters part of the record? Because I looked at the motion to sever, it references the Zwicker letters, but I didn't see them in the appendix.
No, they are not. But defense counsel talked about what was in them and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was, and that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial. And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly which witnesses were involved in those.
What's the significance of the two different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what.
In terms of this analysis, does the state of mind of the two different criminal acts have any bearing?
I don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice. I think the concern when you join those two cases together in this case is that you have evidence of the July assault, which, as you note, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of Kayla Montgomery, and she had significant credibility problems. So to the extent that evidence came in through the joinder of these two cases for trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the defense's calculus with respect to the best interest of justice prong of the analysis, but that when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined? In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder. And so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness. Or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as the cases got towards the trial date, it was clear to the defense, as they made clear to the trial court, that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
I don't know if, I think over a year earlier is when the cases had gotten joined and started towards trial. I don't know at that point whether there was any written agreement or stipulation about evidence, or whether it was tied to the admissibility of other evidence in the case. And the other issue that I want to address this to do with that ruling about some of the evidence that the court determined was intrinsic. I don't think that was any intrinsic evidence issue to the joinder issue.
So the admission of but you would agree, I assume, that the admission of this intrinsic evidence and abuse and neglect that occurred in the weeks before the murder, the admission of this assault in July, that it made it compounded.
Correct. Yes. I mean, I think both issues are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at
Why don't you proceed with the second argument?
yes. So with respect to the intrinsic evidence essential to proving reckless until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
And all this
Doesn't it
evidence-
show the extreme indifference?
I think the charge itself shows extreme indifference. To establish recklessness. And I will also point out that this was not a mental state defense on the homicide charge. This was a defense that Mr. Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent on the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for
To Justice Donovan's point, your yellow light is on, and if you want to get to harmless error.
I do want to get to harmless error. Rested exclusively on Kayla Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her testimony. She gave that story after she had been arrested, jailed, and was facing additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened, and by the time she got to
of the errors alleged in this appeal and the overwhelming
regarding
For it online.
Wow. Classy.
Because I'm looking for the document.
Oh, she said, no fucker, I ain't doing shit.
She's right.
and through witnesses, third-party witnesses without credit to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe
It had joined and the states assented to motion for joinder in the first instance.
no, I don't. And the reason I don't is because my recollection is that the parties agreed to joinder early on in the pendency of the cases. And then as they neared trial, the state did not contest that the defendant had a right to do that and to have the court look again
So if
at
it,
whether it should be
I guess
severed.
my question is, if it was in the best interest of justice at the moment, the defendant agreed to join the cases, what changed?
What
That was
changed
ineffective
is, I think,
assistance.
through the as defense counsel said, through the development of the case in preparation for trial and additional information coming out about how to present its case. And the defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are the Zwicker letters part of the record? Because I looked at the motion to sever references to Zwicker letters, but I didn't see them in the appendix.
No, they are not.
Mm.
But defense counsel talked about what was in them and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was perceiving the state's theory of the case going into trial, that this was going to be a trial about demonstrating a pattern of abuse. And that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial. And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly what witnesses were involved in that.
What's the significance of the two different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what.
In terms of this analysis, does the state of mind of the two different criminal acts have any bearing on our analysis?
She's dropping the
I
ball.
don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice.
She's
I think the
fucking up.
concern when you join those two cases together in this case is that you have evidence of the July assault, which, as you know, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of Kayla Montgomery, and she had significant credibility problems. So to the extent that evidence came in through the joinder of trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the calculus respect to the analysis? That when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined. In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder. And so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness, or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as the cases got towards the trial date, it was clear to the defense, as they made clear to the trial court, that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
Was that tied the intrinsic evidence issue to the issue.
See, but you would agree, I assume, that the admission of this intrinsic assault and abuse and neglect, the murder, that affected admission of this assault in July, that it made it compounded.
Are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at the joinder issue, I think to your point, the prejudice is not just to his trial on the homicide charge, it's also potentially to the trial on the assault charge, because as you point out, the intrinsic evidence came in as intrinsic to the homicide charges. And certainly it was there in the case for the jury to use in assessing both charges, the assault charge and the homicide charge.
So I want to give you an opportunity to address harmless error, but why don't you proceed with your second argument.
Yes, so with respect to the intrinsic evidence issue, there were two pieces of evidence that I focused on in my brief, and I believe it was error. They were not intrinsic to the homicide-related charges, which is what the trial court found. It was the assaults in the weeks leading up to the homicide, and then the bar of communication. With respect to the assaults, the state, even on appeal, says that those assaults, prior assaults, were necessary and essential to proving reckless intent on the homicide. That simply isn't the case. If you look at the state's evidence on the homicide charge, it's the evidence demonstrated, and the state argued that it demonstrated, that Mr. Montgomery acted recklessly by repeatedly punching HM until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
Doesn't it show the extreme indifference?
I think the charge itself shows extreme indifference. The evidence on the charged act, if you believe Kayla's testimony, that in and of itself is more than sufficient to establish recklessness. And I will also point out that this was not a mental state defense on the homicide charge. That Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent on the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for intent, that's a 404B evidence that's subject to a 404B analysis. That's not an explanation for it being intrinsic to the charge.
Wasn't as the trial court noted, wasn't the jury entitled to some context about events leading up to December 7th?
I don't know why. I mean, context has to be tied to the actual the charged act. I don't know, and I guess this is a question for the state, but what about their evidence and proof on the homicide it has a hole or a gap in it that is impossible for a jury to understand and reasonably assess without having these prior assaults.
To Justice Donovan's point, your yellow light is on.
Harmless error. You better get to it.
I do want to get to harmless error. I think that, as I mentioned before, the homicide-related charges rested exclusively on Kayla Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her trial testimony. She only gave that additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened. And by the time she got to testify in this case, she was serving a prison sentence on perjury. She had significant credibility problems. The addition of all of this other evidence, either through the gender and the prior evidence leading up to the assault, the homicide, all of that rested on other evidence. And it gave the jury a reason to, even if they likely had substantial doubt about what Kayla said happened on December 7th, they could find out long assault to the homicide.
Thank you, Attorney Phelan. You've reserved 2 minutes. Attorney Gagne?
She's reserved 2 minutes
Mm-hmm.
for her
Smart.
rebuttal.
Little rebuttal.
Good morning, Your Honors. May it please the court, Sam Gagne for the state of New Hampshire. Your Honors, the trial court committed no error when it denied the defendant's motion to sever, when it admitted intrinsic evidence, or when it admitted the body cam video. But even if it were to be assumed that the trial court did commit an error, any such error was harmless beyond a reasonable doubt, given the nature of the errors alleged in this appeal and the overwhelming strength of the state's case, which consisted of eyewitness testimony, numerous witnesses who corroborated that eyewitness testimony, and a mountain of physical evidence, the summit of which held only one conclusion, and the jury reached it.
Do you agree with the defense that the murder conviction rested predominantly on Kayla Montgomery's testimony?
Not necessarily, Your Honor. Certainly her
A little
testimony
bit.
played a large part. She was the
More
eyewitness
than
to
a
what
little.
happened on December 7th, 2019. There was no specific evidence to corroborate exactly what happened in that car as far as eyewitness testimony. But to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with
I mean, they fucked
the
up.
blood in the ceiling of the fit shelter, Kayla testified that the defendant hid Harmony's body
That's hiding
in
a corpse.
diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went to investigate and cut out that part of the ceiling, it was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the
Yep.
post-homicide actions of the defendant.
Sure, Your Honor. My ultimate point here is that all of these pieces of corroborating evidence of Kayla saying he hid her in the ceiling, he put her in the freezer at Portland Pie Company, he used a U-Haul to drive her and dispose of her body, he used lime to break her body down. If all of those things could be corroborated by physical evidence to show that Kayla wasn't lying about those things, it becomes
That's
a lot
just a
easier
piece
to
of the
credit her
proofs.
testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from bringing blows.
It's not answering the question.
That becomes a lot easier to buy once the rest of her
It's the only thing he can
is
say, though.
credited, and very, very much of her testimony was. Again, through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing. And then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m. and he crossed back over going northbound at 5:25 a.m. The records showed that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again. And that's even before we get to consciousness of guilt evidence.
That's at least something.
Himself. He tells somebody on a jail call that the efforts to find him is just a waste of taxpayer money.
That doesn't help.
One could draw an inference from that I dumped that in a place you're not going to find it. Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls himself a close friend of his that he hated Harmony to his very core.
God,
because Harmony reminded him of Crystal.
What a fucking
That
psycho.
makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for
That's
the
almost
Superior
worse.
Court's decision to allow the pre-December 7th abuse and neglect of Harmony Inn was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description.
She better touch on that in rebuttal.
So what I recall, Your Honor, is in closing, in the final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence or the July 2019 assault.
What?
I do not recall that, Your Honor.
I didn't see it.
I do not recall that from the record. Speaking of, just to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court, my decision is some.
Oh, shit.
Come on, Court TV.
Abuse into September, forbid July, these cases might start to bleed together. So if the joinder order is to remain a sustainable exercise of discretion, the court has.
Oh my God. Wow.
Fresh.
It's Court TV. It's not a refreshing thing.
All right.
The defendant's argument that none of the evidence and that with respect to the 2 weeks prior to December 7th is material to the crime charged?
Yes, Your Honor. First, I note that Attorney Phelan mentioned she did not understand why any of Woodburn respond to that before getting.
That's a good point, Melanie.
Yeah, it's like that on my end too.
Honey, it's Court TV.
Intrinsic evidence cases, events don't happen
Not
in a
us.
vacuum. This
Kidding?
murder did not happen in a vacuum. The whole story is not told by simply recounting the events of December 7th, 2019. If that's all that's told, all you get is that in a vacuum. I'm not saying this would have been the
Off.
Man, I almost
Court
choked to
TV
death.
was giving me a hard time too.
Yeah, it went down the
Defense
wrong pipe
Diaries.
there,
That's
huh?
why I'm sniping you. I hope
Little
you don't
wrong
mind.
pipe action. All right, hold on.
I reset it on my side. It was doing the same thing.
It's not a us issue. It's a Court
I
TV
know.
issue or a court issue. Let me see. I saw the link directly to the courts.
way that a father is supposed to treat a 5-year-old. Her life, he did not treat her the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience. And that evidence showed that. Beyond that, I kind of just wrapped up. It completed the story. And it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story because, again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible? What's the relevance of Manchester Police's encounter with Mr. Montgomery 2 years after the murder?
So that does continue to tell the
entire story of the case, Your Honor, because it's really the beginning of the story from the law enforcement perspective. That's how it starts. That's the first interaction law enforcement has with the defendant. It is relevant that when this is reported to the police, what they know is that Harmony is missing. And they say, okay, let's find the defendant because he has custody of Harmony. And it's relevant for the jury to know when the police located the defendant looking for Harmony, where was he? Who was he with? Harmony wasn't there. That's certainly relevant. There is relevance to that. Now, I'm not going to say that the probative value is through the roof.
It sure was, Mama. This is the case we fell in love at. We were all fired up. That's absolutely true. This is where our love affair started.
It was properly admitted is because the risk of unfair prejudice did not substantially outweigh even small probative value. I contend that it was more than minimal probative value, but even if that's what it was, the risk of unfair prejudice did not substantially outweigh that. The prejudice that the defendant has set forth both in the trial court and in this court is really a tenuous risk of prejudice that is based on mere conjecture and speculation. This video had no audio. The defendant could not be heard. At defendant's brief, page 41, the defendant says the video shows the defendant seemingly answering questions. In that circumstance, and the defendant argues that the risk of prejudice is that the jury is going to infer somehow that he was not cooperative with police or that his right to remain silent was implicated. But the fact that there's no audio, he's shown answering questions, and the defendants carry into trial a presumption of innocence, there was no rational basis to speculate that the jury would take that video and just imply from it that the defendant was being not cooperative with police in that moment while they were just looking for Harmony.
Was there any objection to the testimony about that encounter, separate and apart from the video?
I don't want to say definitively, Your Honor, but I don't believe that there was as I stand here, but my recollection of that is not good enough to answer definitively. The severance issue, the state notes that, as Justice McDonald pointed out, that the defendant initially moved to join these charges and assented to motion and a change of heart, which he was entitled to do. The state notes that the case summary, which I know is part of the state, could supplement if the court wished for it, seems to show an appearance of another defense counsel between the joinder and the motion to sever. And all of this is really to say that it seems odd that defense counsel at one point in time could have reached this conclusion reasonably and then changed their mind and perhaps reached a different reasonable conclusion. Then argues that earlier. Now, Justice McDonald also asked what changed. As the state argued in the trial court, as far as substantive information, nothing changed. What changed was that some of the stuff is now coming from Kayla. That it's lost on me, as Justice Gould pointed out, how that could impact the relatedness factors. Perhaps it speaks somewhat to the interest of justice issues, but it does not speak to the relatedness factors. Secondly, the July 2019 assault evidence, it's a little bit difficult to game this out because it's sort of hypothetical, but if these charges were severed, it's certainly possible, if not likely, that the July 2019 evidence could come into the murder trial under Rule 404B, depending on what the defense and what the state of the facts were. The theories could have been modus operandi, lack of mistake, habit of the defendant in the way he disciplined the child, Harmony, common planner scheme. There's a number of theories that may have come in under anyway. The trial court may have been cognizant of that and thought that was another reason not to try the case twice. But even getting to the Brown factors themselves, the trial court's order is manifestly reasonable. If you go through the 5 factors, the state conceded and the court found there was no temporal and spatial relationship, so that pebble goes on the defendant's scale. The commonality of the victim and the defendant can't be disputed here. That clearly goes on the state scale. The similarity in the mode of operation. In July 2019, the defendant gets angry at Harmony and he punches her in the face. On December 7, 2019, he gets angry at Harmony and punches her again in the head. I see my red light is on, Your Honor, and so we would ask the courts to affirm the trial court's orders and rest on our papers. Thank you.
Thank you very much, Attorney Gagne. Attorney Feeling, you have 2 minutes.
Thank you. If time, I will cover 3 points. Regarding the corroborating evidence, Justice Gould, the state answered your question and talked about it. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct. And Mr. Montgomery at trial did not contest the charges and agreed to the charges of falsifying physical evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reasons herself and credibility problems to not be telling the truth about what happened. Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, tell the whole story. They're very clear whether it's talking about intrinsic evidence or 404B evidence. That those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity purpose.
Yep.
All right.
What happened?
I'm switching it because that feed sucks. So I'm starting right from the beginning. Like, it was very distracting to me. Sorry.
Attorney
Not
Gagne.
sorry.
Attorney Feeling, you have 2 minutes.
Thank you. For 3 points. Just and talked about substantial, in their view, substantial corroborating evidence. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct charges and agreed to the charges of evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reason herself and credibility problems to not happen. Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, to tell the whole story. This court has been very clear, whether it's talking about intrinsic evidence or 404B evidence, that those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity when it's necessary and essential to proving the charged act. The events leading up to December 7 and those prior weeks were not essential and necessary under the test this court has applied for considering whether it's intrinsic evidence.
Why isn't it relevant to whether the defendant snapped on December 7th?
Well, that wasn't the defense at trial. And until and unless
the state
opens the door to evidence under that theory, it's not admissible. And as we know, as the trial played out, the defense was not that this was a lack of intent. The defense was he didn't do it.
Thank you very much, counsel. Case is submitted. Court, take a recess.
All rise.
like this
And then financial
and intent.
hate the vape. Kelsey thing, I think it
You
came to
guys
the
can go and watch the
I
rest
believe a liver
of
surgery
the
thing.
Defense Diaries. I don't want to snipe all of their
Difference the value of life
content. Not sure if
is
they're
really
coming
there.
back.
Beef.
See. This is the piece of shit right here.
This isn't
when he
prejudicial at all.
was, hi, Eagle
Right.
Parts. Hi, baby.
I don't even know what, but I'm surprised the court even asked about it.
Yes, we are
think just
here
to toss it
covering
to
the
the side,
Adam
maybe.
Montgomery. He says that his civil rights were violated.
Sure. Take a peek
Right.
in the car.
I'm just going to cover my daughter's bruises up so you don't see that. Is this is after, oh no, the daughter's in the car.
Huh?
Daughter's dead or is in the car at this point? Now I'm lost. She's already deceased. Sorry.
Trying
Yeah.
to get
There's nothing so far
where
prejudicial. I would
Oh,
think
he's like, can I get a smoke? So I think maybe what we'll do is potentially push that till tomorrow because it is interesting. There's interesting shit in there, and I know.
All right, guys. Well, it looks like that is over, and it was just the prelim to him saying that his civil rights were violated and that, 99.9% of the country thinks it would be a service for him to be under the jail for what he did to Harmony. And people are like, but he might not have done it. It might have been Kayla. They are both at fault, and Kayla should be underneath the jail as well, if you ask me. Tonight, around 8 o'clock, I have to take Kung Fu Panda to an appointment after work. But after that, I'm going to be doing an exclusive. No one's been doing it. There's a young girl. If you guys ever heard of the YouTube channel Soft White Underbelly, he spotlighted this girl by the name of Nova, and she is a 14-year-old prostitute on Figueroa in Los Angeles, and she is in danger. And I watch a few of the YouTube creators that I really do enjoy. I like their work. And they put out a call for action for everyone to give this young girl exposure. Okay. And so we are going to be going over that tonight at 8 p.m., maybe a little bit earlier if I can get my shit together. But around 8 p.m., we are going to be going over some information. So this young girl, I mean, she's putting CP of herself on well-known platforms that have been reported and not taken down yet. Elon Musk must do something. Instagram, do something. She's putting CPSA material online to promote herself due to her being spotlighted on the show Soft White Underbelly. Have I watched Soft White Underbelly? Yes. Do I agree with everything that he does? Do I think that he exploits people? Yes, I do. And he for sure exploited this child not once, but twice, and pays her for her telling her horrific life story. And then it became an advertisement for her to get clients. So we are going to be putting a spotlight on that tonight at 8 o'clock. Hopefully you guys will all be there and get all the exposure that Nova needs, because she's a child being exploited by grown-ass adults. Yeah, exactly, Equal. How will she make a living? She is, by all accounts, a street worker and advertises herself. And her mother, with 6 other kids, introduced young Nova to this lifestyle because she too is a streetwalker. Wait until we get into it, kids. It's as devastating as it is. This young girl needs publicity. The videos need to be taken down. The Center for Missing and Exploited Children needs to be contacted. I mean, we're talking, and Nova is just one of many girls that this happens to, and we are going to put a spotlight on the YouTube creators that promote her and her services and call her fast and young. Like it's disgusting, and this happens in our own backyards. She is in California. There was a YouTuber that contacted the FBI, local authorities, the platform themselves, and nothing has been done about taking the CP off of the platforms that all of us frequent. So it affects all of us. It affects us as parents. It affects us as community members and taking care of children who are defenseless and that cannot consent to anything. That's why they have to have their parents sign for them to have surgery. I don't know, kids. All right. So that was that. Fuck Adam Montgomery. And we will be back tonight for more. Come and expose the degenerates that exploit young children. So I hope to see you tonight. Bye, kids.